If someone in your family ever has a mental health crisis and you're the one who has to decide whether to call police, you need to understand a Supreme Court ruling from earlier this year that quietly determines exactly what those officers can legally do once they arrive at your door. This isn't an abstract legal question. It's the exact scenario that plays out in homes across the country every single day. When someone calls 911 terrified for a loved one's safety, and the officers who respond have to make a split-second judgment call about whether to force their way into a home without a warrant. On January 14, 2026, the Supreme Court ruled unanimously, 9-0, in a case called Case versus Montana, settling exactly how much evidence police need before making that call. What happened to the man at the center of this case, and what's happened in the months since the ruling came down, tells you everything about what to actually expect the next time a mental health crisis in your own family intersects with a 911 call. Most people who hear about a 9-0 Supreme Court ruling assume it means the question is now simple and settled beyond any doubt. As you'll see, this ruling is genuinely important, but it comes with real nuance that matters enormously if you're the one actually living through a moment like this rather than just reading a headline about it afterward. Before we get into it, if this is the kind of practical breakdown you want before you're ever in this situation yourself, subscribe and turn on notifications right now. I cover exactly these intersections between constitutional law and real, everyday family crises the moment courts clarify them, because understanding your rights and what to realistically expect matters most before you're standing in the middle of an emergency, not after, when adrenaline and fear make it far harder to think clearly about anything, let alone a legal standard you've never actually studied. Let's get into what actually happened and what it means going forward. Here is the case that forced this question all the way to the Supreme Court. William Trevor Case, an Army veteran living in the small town of Anaconda, Montana, had a documented history of mental health struggles, including prior suicidal behavior that local police already knew about from past encounters. On September 27, 2021, Case called his ex-girlfriend and told her he was going to kill himself. During the call, she heard what sounded like a gun being cocked, then a sound like a gunshot, followed by silence. Terrified, she called 911. Officers who knew Case personally responded to his home. They knocked and shouted through an open window but got no answer. Through the window, they could see an empty gun holster and a notepad with writing that looked like a suicide note. Believing Case might be seriously injured, they entered the home without a warrant to check on him. As officers approached a closet where Case was hiding, he threw open the curtain holding an object that looked like a gun. An officer, fearing he was about to be shot, fired and injured him. A handgun was later found nearby. Case survived, was charged with assaulting a police officer, and argued in court that the warrantless entry into his home violated his Fourth Amendment rights, setting off a legal fight that ultimately reached the Supreme Court more than 4 years after that night. The first segment of what you actually need to know is the legal standard the court settled on, stated in plain terms rather than legal jargon. Police can enter your home without a warrant during a perceived emergency if they have what the court calls an objectively reasonable basis for believing someone inside is seriously injured or in imminent danger. That is not the same as full probable cause, the higher standard normally required before searching a home in a criminal investigation. It is a real standard, meaning officers still need specific, articulable facts, not just a vague feeling or a general mention of mental health concerns. But it is a standard officers can satisfy more readily than the traditional probable cause threshold used in criminal cases. In Case's own situation, the specific facts that satisfied this standard were the reported sound of a possible gunshot, no response at the door despite genuine attempts at contact, a visible empty holster, and what appeared to be a suicide note. That combination of concrete, specific indicators, not a single one of them alone, but all of them together, is what the court found sufficient. It's worth being precise about what would likely not be enough under this same standard, because understanding the floor matters just as much as understanding what clearly qualifies. A vague second-hand report with no specific details, someone simply saying they're worried about a family member without describing any concrete indicator of an ongoing emergency, would likely fall short of what this ruling actually requires, since the court's own concurring opinions specifically caution against treating general concern alone as sufficient justification for entry. The second segment is what this means if you're the person making that 911 call, because your own account of what's happening genuinely matters for how officers will later be judged to have acted. If you call 911 about a loved one in crisis, be as specific and detailed as you can about exactly what you're seeing, hearing, or have reason to believe, because the specificity of the information relayed to officers becomes part of the factual record that later determines whether their response was constitutionally justified. A vague call reporting general worry carries less legal weight than a call describing specific, concrete indicators. A sound that could be a gunshot, a stated intent to harm oneself, a specific weapon mentioned, prior history the caller is aware of. This isn't about performing distress for legal purposes. It's about understanding that the information you provide genuinely shapes what officers are legally entitled to do once they arrive, and providing clear, specific, honest detail actually helps ensure the response that follows is both effective and legally sound. The third segment is what this means if you're the person police are responding to check on, or a family member trying to understand what happens next in that situation. Understand that if officers have specific, articulable facts suggesting an ongoing emergency, the kind described above, they now have clear, unanimous Supreme Court authority to enter without a warrant and without your consent, and refusing to answer the door will not, on its own, prevent that entry if the underlying facts already support the objectively reasonable basis standard. This is different from the wellness check scenario addressed in the earlier Caniglia ruling, where officers were making a more generalized safety judgment after the fact rather than responding to an active, ongoing, specifically described emergency. If you are the subject of this kind of call, the safest response, both for your legal position and for your actual physical safety, remains staying calm, making your presence and condition known to officers as clearly and quickly as possible, and avoiding any movement that could be misread as a threat. Exactly the kind of split-second misunderstanding that turned Case's own encounter into a shooting. The fourth segment is what this means for police departments and officer training nationwide, because a single unified Supreme Court standard changes how departments across the country write policy and train officers, not just how individual encounters get judged after the fact in court. Before this ruling, departments in different states and even different federal circuits within the same state in some border areas were training officers according to meaningfully different legal standards for when emergency entry was justified. Departments in jurisdictions that had previously required something closer to full probable cause may need to update training materials and internal policy guidance to reflect the somewhat more permissive, though still real and specific, standard the Supreme Court has now confirmed applies nationwide. Many police departments across the country have also expanded co-responder programs in recent years, pairing officers with trained mental health professionals or crisis intervention specialists specifically for calls involving a psychiatric or suicide-related emergency. And legal analysts note that Case versus Montana doesn't discourage that trend at all, since the objectively reasonable basis standard applies regardless of who physically enters the home first, meaning departments with these co-responder models can continue relying on them while still operating within the same nationwide legal framework the court just confirmed. Legal experts who track how Supreme Court rulings filter down into actual department policy note that this kind of update typically takes months to fully implement, meaning officers in some jurisdictions may continue operating under older, more restrictive internal guidance for a period even after the nationwide legal standard has technically changed, a gap worth understanding if you're trying to predict how a specific department in your area is likely to respond to a call like this right now. If you want to know how your own local department currently trains officers on this exact scenario, most departments' general orders or policy manuals covering use of force and emergency response are public records, and requesting or searching for your department's specific crisis intervention policy is a concrete way to understand what officers in your community are actually instructed to do, rather than relying only on the nationwide legal floor the Supreme Court has established. The fifth segment is what Justice Sotomayor's concurring opinion specifically adds to this picture, because it matters for anyone worried this ruling simply hands police unlimited discretion. Sotomayor wrote separately to stress that officers responding to mental health crises should genuinely consider de-escalation strategies and less invasive alternatives before deciding that immediate entry is necessary, signaling that the objectively reasonable basis standard is not meant to function as an automatic green light the moment any call mentions mental health or self-harm in the abstract. Mental health advocates and civil liberties organizations tracking this ruling have specifically pointed to Sotomayor's concurrence as an important marker for future litigation, one that future courts reviewing similar cases can and likely will cite when evaluating whether officers in a specific encounter genuinely had the kind of concrete, case-specific facts case's situation involved, rather than accepting a vague, generalized justification after the fact. This distinction matters enormously in practice because it means the ruling protects genuine emergency response while still preserving real accountability for situations where officers might otherwise be tempted to treat any call touching on mental health as automatic justification for entry regardless of the actual specific facts available to them. The seventh segment is the physical safety piece of this that matters just as much as the legal analysis, because Case's own encounter turned violent at the exact moment he made a sudden movement that officers reasonably interpreted as a threat, and that single moment is worth walking through carefully. If police have entered your home during a genuine emergency response, whether you called them yourself or a family member did, the safest thing you can do, for your own physical survival above all else, is make your hands visible immediately and avoid any sudden movement, especially toward anything that could be mistaken for a weapon, even if your actual intention is completely innocent. Officers entering a home under these circumstances are operating with real fear for their own safety, often heightened specifically because they've been told there might be a weapon involved, and the split second between an officer perceiving a threat and reacting to it is not the moment to explain your intentions verbally first. If you are able to, speaking calmly and announcing your location and that you're unarmed before officers reach you can help. But the physical safety principle that matters most is simple. Keep your hands visible, move slowly, and avoid reaching toward anything, including toward your own phone or a piece of furniture, until officers can clearly see you present no threat. This isn't about surrendering your legal rights. Your Fourth Amendment rights regarding the legality of the entry itself remain fully intact and can be challenged afterward through the legal process if you believe the entry wasn't justified. But the specific moment of physical encounter with officers who believe they may be facing an armed, distressed individual is not the moment to make that legal argument. It is the moment to survive it, so that the legal argument can actually be made afterward with an attorney in a courtroom, rather than never being made at all. Before we get to the legal aftermath, it's worth pausing on something more important than any court ruling, which is that families dealing with an ongoing mental health crisis often benefit enormously from planning ahead of an emergency rather than only reacting once one is already underway. Many communities now have crisis intervention teams, specially trained officers or co-responder programs pairing police with mental health clinicians, and calling your local non-emergency line ahead of time to ask whether such a program exists in your area and how to request it specifically during a future crisis call can meaningfully change how a future encounter unfolds. Some families with a loved one who has an ongoing history of mental health crises choose to proactively inform local police, outside of any emergency, about that history and about what de-escalation approaches have worked in the past, giving responding officers useful context before they ever arrive at the door during an actual crisis. None of this is a substitute for the legal protections we've been discussing, but it reflects the same underlying idea running through Case versus Montana itself, that these encounters go better for everyone involved when officers have specific, concrete, accurate information rather than having to guess in the moment based on fragments of a phone call. The sixth segment is what happens next if you or a family member end up in a legal dispute over a similar entry, because Case versus Montana is now the controlling precedent any attorney handling a suppression motion or a civil rights claim involving a similar fact pattern will have to address directly. If you believe an entry into your home during a claimed emergency wasn't actually supported by the kind of specific, concrete facts this ruling requires, an attorney experienced in Fourth Amendment litigation can evaluate whether the objectively reasonable basis standard was genuinely satisfied in your specific circumstances, or whether officers instead acted on the kind of vague, generalized concern the concurring opinions specifically flagged as insufficient. This is a fact-intensive inquiry, meaning the outcome depends heavily on the specific details of what officers actually knew and observed in the moment, not a simple yes or no answer that applies uniformly to every case involving a mental health-related 911 call. Let's step back and name what this ruling actually changes for ordinary families navigating a genuine crisis. Before January of 2026, the exact legal standard governing this exact situation, a family member in crisis, a 911 call, officers deciding whether to enter without a warrant, depended meaningfully on which state or federal circuit you happen to live in. Today, there is one clear, unified, nationwide standard confirmed unanimously by all 9 justices that answers this question the same way regardless of where in the country the crisis unfolds. That standard is real, and it does allow officers to act on specific, concrete emergency indicators without first satisfying the higher probable cause threshold used in criminal investigations. But it is not, according to the court's own concurring justices, a blank check for treating any mention of mental health as automatic justification for entry. It's worth sitting with the fact that no legal standard, however carefully drawn, fully resolves the underlying difficulty of these situations. Case's own encounter shows exactly how quickly a genuine emergency response can turn into something far more dangerous, even when officers are acting with the best of intentions and even when, as the Supreme Court ultimately found, their initial decision to enter was fully justified under the law. The legal question of whether an entry was constitutional and the practical question of how to physically survive an encounter with officers who believe they may be facing an armed, distressed person are related but genuinely separate concerns, and understanding both matters far more than understanding either one alone. A family that only knows their legal rights but hasn't thought through the physical safety piece, and a family that only knows the safety piece but has no idea what legal recourse exists if an entry genuinely wasn't justified, are both missing half of what actually matters when a crisis like this unfolds in real time. If you take one thing away from this breakdown, let it be this. A mental health crisis in your own family is one of the most frightening situations anyone can face, and understanding exactly what the law actually requires and what it doesn't before you're standing in the middle of one gives you something concrete to hold on to in a moment that otherwise feels completely out of your control. This ruling didn't eliminate the difficulty or the danger inherent in these situations. It gave everyone involved, families, officers, and the courts that later review what happened, one clear, unified standard to work from, replacing years of inconsistent rules that depended entirely on geography. Talk through this with the people in your own household now, while things are calm, rather than waiting to figure it out in the middle of an actual crisis, because the 15 minutes it takes to understand your rights and the practical safety steps that go alongside them could genuinely matter someday. If this helped you understand a ruling that could genuinely matter to your own family someday, Share it with someone who has a loved one dealing with mental health struggles. Subscribe so you catch the next major ruling the moment it clarifies your rights, and I will see you in the next one.